For those of you that have been with us for the last couple of conferences, you know that privacy has been a topic of conversation. A few years ago, SNS coined the term aorta, which is always-on real-time access. Aorta produces what is some are calling the new oil, a lot of data. And it's a tremendous amount of data. And for those of you keeping score at home, IBM predicts something on the order of 8 zettabytes by 2015. A zettabyte is equal to 1 billion terabytes. That's an awful lot of data, and that's an awful lot of oil. And so that's what some people mean when they say the words big data. Think about the implications for this. Cars that talk to each other, but not to people. Cars that talk to people that say, sorry, the driver of this car cannot speak with you now. They're currently driving and unable to text. The implications are very large and also very complicated. We are very, very blessed to have someone to help us today kind of sort through some of this very, very rapidly evolving landscape. And that is David Vladeck, seated to my left, who is the head of the Consumer Protection Bureau of the Federal Trade Commission. And we've asked David to help us understand kind of 3 things today. The first is the privacy landscape is really moving very quickly on a global scale, both here in the United States, but also in other parts of the world. There's a lot of variables, and hopefully we can isolate some of those today. There are some risks that are also presented to global companies that are moving data around the world. We'll get into that a little bit. And then finally, there are new requirements which will be placed on companies as they create, for instance, apps, enterprise-level apps that go out into their own ecosystems and beyond. Underneath all of this, and where we will end today before we take some questions at the end, is the trade-off with the developments that are happening on the privacy front on a global basis, balanced by the imperative for innovation, which is a key topic of conversation for the individuals in this room. So why don't I kick that off first with a thank you to you.
Sure.
And ask you to help us understand what is actually happening legislatively, landscape-wise, both here in the United States but also in Europe.
Well, it's a complicated question, and I'll try to give you a simple answer as possible. Up until about 3 years ago, the dominant framework for consumer privacy was called notice and choice. The theory was that as long as you gave consumers notice of some kind and gave them a choice of some kind, your obligations were satisfied. And as you all know, this framework resulted in obscure privacy policies written by lawyers trained in the art of obfuscation that were hard to find and impossible to understand. That, coupled with what was generally opt-out choice, that is, if you didn't like something, you had essentially a take it or leave it offer. And, well, that might have been an okay framework for the paper era, didn't map on well to the internet era, and certainly is not going to map on well to the smartphone era, which is upon us. Imagine trying to read a privacy policy on a smartphone. We've tried. It's not worth trying to do. And so in mid-2009, the FTC and the EU embarked on a rethink of privacy to try to move privacy into a contemporary framework. Shortly after the FTC got started, the Commerce Department and the White House started thinking about this more broadly from the administration's perspective. And so what we have are competing models that are emerging from the United States on one hand and from the EU on the other. And let me briefly go through both models. In the United States, if you take together the work of the White House and the work of the FTC, you have a model that's built on really 2 separate components. One is basic, fundamental privacy legislation that provides a baseline. Data management and safeguards, restrictions, but not hard restrictions on data collection and retention, to be built upon by a self-regulatory process overseen by the Federal Trade Commission and ultimately enforceable by the Federal Trade Commission. And this sort of framework has a number of key components. Giving consumers control over their own data, having transparent data practices, taking context into account so transactions that the consumer would expect would not be subject to the kinds of controls that unexpected transactions would be, better data security, access and accountability, and ultimately enforcement by the Federal Trade Commission. Most of what would be thought of as regulation would be self-generated industry codes of conduct, supervised by the FTC and enforceable by the FTC, but they would be flexible and they'd be generated by industry in large measure to avoid putting speed bumps on the superhighway towards innovation. We understand that we don't have a monopoly on wisdom, and we don't want to interfere with the innovation that has driven this industry probably at a velocity unmatched in history. Now, the EU has a very different legal tradition. They come from a code tradition where the law is spelled out in exacting detail by the legislature. And for the last 10 years or so, the EU has had non-binding directives. There's the European e-privacy directive and the EU data protection directive, which collectively set a very prescriptive framework for companies that collect data to operate under. Some of the byproducts of this are the cookie fight that's going on in Europe. This is not Oreos versus chocolate chips. This is whether companies can place cookies on people's computers without first getting their express affirmative consent. In a Google search, Google may place as many as 10 or 12 cookies on your computer. Imagine if at each step of the way you had to give your express affirmative consent to placing that cookie. It would take you 20 minutes to do a single search. So their model is prescriptive, but so far it's been decentralized. 6 months ago, the EU's Directorate General for Justice, it's their Justice Department, proposed sweeping overhaul of the EU data privacy laws to have a uniform EU law that contains a number of features that worry us. We're glad to see they're moving forward. We think in many respects a unified EU law would be better for American companies than trying to fulfill the patchwork state of regulations that the EU now imposes. But there will be a right to be forgotten, which may require deletion rights above and beyond anything that are currently available under US law, rights of portability, special rules for children, strict regulation of data breaches and data security, including very substantial sanctions that are possible. A claim of worldwide jurisdiction. The EU claims that it would have jurisdiction over US companies with no physical presence in the EU as long as their services were available in the EU. And given that these are internet-based services, hard to imagine a service that wouldn't be. There are also provisions that cast down on data transfers, the interoperability of data transfers between the United States and the EU. So we've been working very closely with our counterparts in the EU to try to make them understand better some of our concerns. It's a political process in the EU. They need to get both the Council of Europe and the EU Parliament to adopt these measures. But there is real concern within the United States that some of these measures won't map on well to the way our companies currently do business.
I'm not sure if this is an accurate description or not, but I've heard one person said that the approach from the EU is guilty until proven innocent. In other words, you have an affirmative obligation to prove innocence, whereas the approach in the United States is largely the opposite, innocent until an enforcement action.
Yeah, I would put it differently. The EU is rule-driven, and therefore any violation of the rule makes an entity liable for sanctions. And there are a lot of people who drive more quickly than they should. In the EU, all of them will be, at least as a theoretical matter, subject to sanctions. I would say this, the EU thus far has not been an enforcement-based regime. In contrast to the FTC, we have, in some ways, crafted our law of privacy through enforcement actions against Google, Facebook, Twitter, MySpace, and a host of other big internet service providers.
So among the companies in this room, which are, largely sort of big tech participants. What are some of the things they should be thinking about, and how should they be thinking about designing, for instance, everything you should know, every CIO should know about the cloud, for instance?
Well, the cloud, like many new technological breakthroughs, the cloud provides all sorts of innovation benefits, opportunities for the creation of new and better products, wider and much more, much quicker data access. So the cloud is here to stay. It provides all sorts of innovation and benefits. From the EU's perspective, they're concerned about cloud. And they very much want to see servers that are serving the EU within the EU. Facebook, for example, its servers that serve the EU are in Ireland. We're not opposed at all to cloud-based services. We are concerned, like the providers of cloud services, about data security. And I would say that thus far, the big service providers in cloud tend to provide very robust security measures. We have not seen, although this has been forecast for the better part of a decade, serious breaches based because of the cloud ways of storing data. But those are legitimate concerns. I think that, and this is a message that is not restricted to cloud, if you're going to hold on to people's personally identifiable information, you are stewards of that information and need to provide reasonable security. The security breaches that we've seen, and we've seen many really serious ones, due to, in our view, lax security measures, have nothing to do with the fact that the data is in the cloud rather than in a server down the hallway. So, cloud presents all sorts of interesting issues, but I think cloud is here to stay, and the opportunities that it's going to offer are substantial.
Are there specific business models that you believe, based upon the global agenda, specific business models that might be at risk as a result of these changes?
The EU's changes or our changes?
Well, and both, I guess.
I think that the EU's changes, I think, are most problematic for the larger U.S. companies that work globally, that will be struggling, I think, to meet some of the more unusual demands of the EU. For example, the right to be forgotten, the way it's conceptualized in the EU proposal, is a right not only to delete information that you have posted on the web, but let's take the paradigmatic example. You and I are photographed together. We like one another. You post or I post our picture on Facebook. Under EU law, if I post it, you would have the right not simply to insist that it be deleted from my Facebook page, but you would have the right to insist that Facebook essentially try to figure out who else on the web may have downloaded our picture. And it would be up to Facebook to try to get other web hosting sites to take that picture down. Whether they want Facebook to web crawl and to identify every last other photograph or not is unclear, but the burden would plainly be placed on the site you posted that photo on to sort of police the rest of the web. Now that's an enormous burden, and it's a burden that isn't just a technical one, although the technical problems are enormous. Whose photo is it? Jeffrey Rosen calls the right to be forgotten, as conceptualized by the Europeans, the biggest threat to free speech on the internet in the coming decade. Because, in the EU, the right to privacy is a fundamental right. The right to free expression is also a fundamental right, but is subordinated to the right of privacy. And so they're unconcerned with people requiring the deletion of data that's otherwise publicly available. And so part of what's going on is a philosophical disagreement between the EU and the United States. And let me just, I'm not trying to be alarmist, but this is a debate that's going to have global ramifications. South America, Asia, they're struggling with what privacy regimes to adopt. They're looking at both the United States and Europe and trying to figure out which of these competing models makes more sense. Now, the European model has a lot of rhetorical power to it. Privacy is fundamental. Consumers have a right to privacy. It's the consumer's data. They have absolute control. In my view, that argument sort of sidesteps the fundamental question about innovation in the web. Innovation in the web has been largely fueled by online behavioral advertising. The goose that lays the golden egg is the ability of startups to monetize the data that they're collecting and use it to fuel further innovation. Now, some of these innovations may or may not be socially useful, but many of them plainly are. And so the question that we're wrestling with is how do we allow innovation to go on unimpeded, but at the same time give consumers back some control over their personal data? In our view, and we've issued a lengthy report which explains all of this in great detail, it's on our website, March 2012. Our principal concern isn't online behavioral advertising. It is a principal concern of the Europeans. Our principal concern is what other uses are the data that is collected through online behavioral advertising being put to? It's being sold, and some of it is being aggregated by data brokers. It's one thing to give up your data to Amazon or to any other, or to Google, and get in returns targeted ads that may be specifically calibrated to something that you are interested in, or at least the person who uses a computer you share is interested in. It's another thing that if I'm searching for, this is a hypothetical, I assure you, deep fat fryers on the internet. It's fine if I get ads for that thing. It's not at all clear to me that I want data brokers to sell that information as well as other information about my browsing habits to prospective insurers, employers, lenders, and the like. So if you look at our report, what we're worried about and what we propose some legislative changes to are the data aggregators, the data brokers who are engaged in activities that are not really contemplated and not within the reasonable expectations of consumers. That's our principal concern. But the Europeans, because of their focus on individual privacy rights over everything else, are really concerned about the initial collection of the data. We want to give consumers more control over that, but we're equally, if not more, concerned about the uses to which that data is put.
So the risks are plentiful and they're all over the place. You can assume that this room is largely the top of the marketing food chain, if you will. These are the enterprises that have agents and employees that manage customer acquisition and retention programs through various product lines. From your perspective in the U.S., who's got the burden?
Well, so there are many different burdens. A company that's collecting individual, personally identifiable information, that company and everybody senior in it has an obligation to safeguard that data. We see far too many data breaches because companies don't patch their systems the way they ought to. So one burden is on the company itself to safeguard personal information. A second burden is to, when you are collecting information from consumers, be transparent, particularly where the context is one the consumer would not expect. So I'm your customer. I give you my mailing and shipping information and my account information. You don't have to tell me you need that for the transaction. I get that. On the other hand, if you're going to take my data and sell it to a data broker, you should tell me that. And maybe you should give me a choice about whether I want that to happen. We're worried about take it or leave it offers where you're dealing with large platforms. Part of what we've done is we're going to hold a workshop sometime in the fall on what do we do about large platforms and their ability to engage in comprehensive tracking. So ISPs, platforms that control access Google's, Android, the operating system Apple uses. These are platforms. These are gateways. And the ability to operate a platform gives you the ability to track multiple consumers, millions of consumers, comprehensively, completely across the web. Should a cable operator, for example, be able to tell you, you can't have cable unless you agree to deep packet inspection. Deep packet inspection will allow them to see everything you do on your cable. What movies you rent, what shows you watch, when you fast forward through whatever. And those are tough questions. I mean, or should, in parts of this country, there's only a single cable provider. Those are tough questions.
Or if your car talks to you.
Well, your car talks to you. Though we had a skirmish with GM earlier this year about using OnStar for tracking other than for emergency services, and GM backed down because it hadn't disclosed to consumers that in addition to providing this emergency service, GM was going to use the data for multiple other purposes. I don't know what final decision GM has made about how to use that data, but they're going to have to go to their consumers and at least make it crystal clear to the consumers, apart from the advertised service, which is if you drive yourself into a ditch, call us, we'll come get you out, what other functions they're going to use for that data.
Let's close with the innovation question where we started.
Right.
And then if there's some questions, we can take those. We have just a couple of minutes left. So with all of this moving around, right? And it's likely to move around for some years to come, I would say.
Right.
How should this group, what sort of lens should they view innovation through? And how do they trade that innovation for, the privacy imperative?
Well, I think in the United States and probably in the globe, I just want to put a slight asterisk to Europe. This is a field that is ripe for innovation. We've just started. I mean, Facebook is all of 8 years old. It already has 850 million customers or users worldwide. Google's usage rates are astonishingly high. The penetration of Google is much higher outside the United States than it is inside the United States. 2/3 of Americans use Google for search. 92% of Europeans use Google for search. So I think that this is a wide open field with the government, at least in the United States, standing on the sidelines, cheering you on with one small little caveat. Be respectful of consumer privacy. It shouldn't be an obstacle to innovation, but it should be built in, and there are ways to design privacy by design to allow your business models to go forward without impeding or interfering with consumer privacy. There's also opportunities for privacy innovation. One of the most fertile areas of investment and innovation are for privacy-enhancing technologies. And not surprisingly, many of the biggest companies are working simultaneously on developing new products, but are also developing products that will provide consumers greater choice when it comes to protecting privacy. The EU is a complicated story. I don't know where the debate in the EU will come out. A lot of this ultimately depends on a philosophical question. Is innovation more important or equally important as privacy protection? The Europeans, I think, are having a debate about that. I don't know where it'll come out. I know where we come out on it. And frankly, I think if you look at the companies that are the innovators in this space, most of them are within 500 miles from here. So I think the landscape looks very rich and inviting for innovation here. We want to help. We don't want to get in the way.
He's from the government. He's here to help.
Yeah.
Are there any questions from the audience? Sorry, you're first?
So lots of questions, thoughts, but to be specific, the EU is forced, it sounds like, your group to at least think, maybe interact on what may come, and it's, I think, healthy probably for that to happen. But even without that, What kind of input do you get in your own thought processes, your teams? Is it mostly from industry, mostly from consumers? How do you break that down? And also, if you can address it with respect to HIPAA, because that's one area where I think innovation, and it's probably mistreated in many ways, misunderstood, and if it wasn't so politicized, probably could be improved.
So let me reverse my answer. We don't have jurisdiction over HIPAA. HHS does.
Right.
And HIPAA is a reflection of what I think are the patchwork of sectoral laws that we've relied on for privacy protection that I'm not sure have served us all that well. I think HIPAA is in many respects a flawed statute.
Agreed.
But in terms of what the FTC has done, before we did anything, we did 3 workshops around the country, including one in Silicon Valley, to encourage all stakeholders, privacy advocates, business leaders, innovators, app developers, to come talk to us. And we have an ongoing dialogue with virtually everyone in this space. There's a lawyer in San Francisco whose job it is to do outreach to the app development community, because frankly, it's a very diffuse industry. Apps are really interesting, but most of these are, and this is not being sexist, most of these app developers are 20 to 25-year-old guys. They're brilliant, but they don't know what the law requires. And we're seeing a lot of inadvertent legal violations by these app developers. I don't want to sue them, I just want to tell them what the law is. And so we're doing an enormous outreach to that community. We don't have any monopoly on wisdom. Most of the recommendations that we made are based on, if not consensus positions from the stakeholders that we've been engaged with, but at least strongly supported recommendations. They'd have support across the board. Ours has been a very bottom-up process. The EU's process, I think, has been very top-down, and I think one of the reasons why it is so out of touch with, I think, what the technologists would say is because they've really not yet sort of meshed with the people who are active in this space.
Thank you.
Why don't we go to this side?
Yeah, just a thought from the EU side of things. As a citizen of the United Kingdom, one of the things that's noticed by people that the American organizations try to apply their own legal framework already to the internet. And so from the European side of things, it's more a rebalancing. If you take a relationship with Google, you are required to sue them in the state of California, which is inequitable. For someone in Europe, it's unaffordable to do that. Also, the US government uses the Patriot Act to claim eminent domain over data stored in cloud services globally. And so do you not see this as being an equitable response from Europe to rebalance an already unbalanced privacy set of laws?
So let me say 2 things. One is I spend a lot of my time with my European colleagues. The FTC is the data protection agency for the United States. I spend a lot of time working with the Article 29 Working Group, which is the group of data protection authorities in Europe. There is no question that part of the EU's proposed regulation is an effort to discipline US companies and to get them to act much more in accordance with the EU's directives than they currently do. And some of that, I completely agree with you, is legitimate. And some of these proposals, it depends on what your philosophical orientation is, whether you think these are great steps forwards in terms of implementing the EU fundamental right to privacy, or the other side of the argument is putting speed bumps on the information superhighway. And so I don't disparage the Europeans. They have a fair point. But I think they have to acknowledge that if the EU directive, the proposed regulation is implemented as drafted, it is going to interfere with the ability of companies to do their work the way they've historically done it. And it may, in my view, stifle innovation, which is not really helpful for anyone.
We are 4 minutes over time, so David, can you keep it crisp?
Oh, well, I'm not going to defend the Patriot Act or any such thing. I just want to say that the tendency is always to try to reflect, and far worse in Europe, I've lived over there. I've talked to these people very much. The reflex is, with all best intentions, to protect people from above with paternalistic controls on the flow of information. And that is the road to hell, because elites will always find hiding places in that. As Robert Heinlein once said, the chief thing achieved by privacy law is to make the spy bugs smaller. The proper response, which we sort of reflexively move towards in America, is increase the information flows so that people can protect not their ownership of these informations, but their interests in earning whatever income there is to have from their information. And that can only be achieved by letting everybody know how the information is being used. And there's a very different thing.
So in the spirit of transparency, we are over time. So David, thank you very much.
Thank you.